All right, Assemblymember Chow is here, and he has file item 18 and 24. So let's go with file item 18. Good afternoon, Assemblymember Chow.
Good afternoon. Thank you very much, Madam Chair and Senators. First of all, I'd like to state that I'm accepting the amendments suggested on page 6 of the analysis. The amendment that is being taken has been agreed upon to ensure that the representatives can also obtain coroner's photos as long as they provide a declaration under penalty of perjury and provide a valid ID and also a certified death certificate. AB 2427 makes 2 procedural changes to the Code of Civil Procedure to make legal proceedings more efficient. First, the bill will allow legal heirs and representatives to obtain coroner's photographs without seeking a court order. Currently, legal heirs and representatives of a deceased individual cannot access the coroner's photographs of their deceased family member without first seeking counsel and then permission from the court. They must also incur the expense of hiring an attorney, obtaining a court order for the photographs. Then, based on that information, they decide how to proceed. The bill also deals with the discovery procedure. Under current law, parties may demand materials and reports relied on by expert witnesses. However, the law provides no time frame for producing these reports and materials. And oftentimes, the expert's file is produced only at the beginning of the deposition, for example, leaving counsel conducting the deposition with no time to evaluate the information being questioning the expert. The bill requires these materials to be produced 3 business days prior to the expert deposition. These 2 changes to the CCP will make litigation more productive to the litigants, lawyers, and also the court. Today, I have 2 witnesses to testify to support the bill, and I'd like to turn it over to them.
Sure. Thank you very much, Assemblymember. Your witnesses, good afternoon.
Thank you, Madam Chair, and committee members. Again, my name is Elise Sanguinetti. I'm the president of the Consumer Attorneys of California. I'm here to present AB 2427, which is co-sponsored with the Defense Council and the Consumer Attorneys of California. We work together in an annual effort to find court efficiencies, and this was one area that we identified that we could work on together and present as a bill that could help with efficiencies. I'm going to speak first on Section 1 that Assemblymember Chow just mentioned, which deals with who can request and how this changes the current law. Currently, legal heirs or representatives of a deceased individual cannot access coroner photographs without hiring an attorney and making a motion in court, which is not an efficient way to accomplish what they need to accomplish, which is getting the coroner photographs. Oftentimes, those photographs are needed in order for someone to determine whether or not there is a case to pursue. So if you have to hire an attorney first, then go to court to ask for those photographs, we're not doing things in the most efficient manner. So this would change that so that now, and there's amendments that have been put in place to address any concerns regarding the stature of the individual that's requesting it, the status, and making sure that those individuals are truly the heirs or legal representatives. So what this allows now is an efficiency where the court doesn't need to be bogged down with a motion to ask for coroner's records, which are really never opposed. They're provided, but it just causes more of a headache in court. And so now this instead would allow for a request from the heirs prior to file, and they don't have to hire an attorney to file a motion in court. They can request these photographs themselves, and then a determination can be made whether or not they want to move forward with litigation or use them for any other purpose. So I am here to ask for your support and your aye vote, and we'll pass this along to
Mike Bullock?
Yes, Mike.
Thank you very much.
Chair and members, Mike Belote on behalf of the California Defense Council. As Ms. Sanguinetti indicated, this is a bill co-sponsored with our friends in the Consumer Attorneys. Our suggestion for the bill relates to the exchange of the so-called experts file, which is demanded through the discovery process. Present law says you can demand the writings and so on of the expert, but it doesn't say when, and very often we find on both sides that this information isn't exchanged until the beginning of the deposition itself. Sometimes just a thumb drive handed over to the other side. We thought if we could get the information a little earlier, the deposition would be more productive, thereby reducing people's costs and making litigation a little more efficient. Our members like the idea. We convinced the plaintiffs' bar that they should like it too. They agreed. We put it in the bill, and we'd ask for an aye vote.
Thank you very much. Any other witnesses in support? Any witnesses in opposition? We'll bring it back to the dais. I just want to be clear that you are accepting the second of the suggested amendments on page 3, line 15, striking either of the following and inserting both of the following.
That's correct.
Is that correct?
That's correct.
Very good. All right, any questions? I think this is a good measure. It's kind of common sense in a way, and hopefully will help make the process cleaner and more efficient. So there's a motion by Senator Wojciechowski, and with that, if you'd like to close, next one's yours.
I respectfully ask for aye vote.
Very good, thank you. Please, the motion is do pass as amended to the Senate Committee on Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Monning? Wojciechowski?
Aye.
Wojciechowski, aye.
That bill has 4 votes. We will hold the roll open for absent members. Thank you very much.
Madam Chair, if I may present AB 2828 now.
That is file item 24, AB 2828. Please proceed.
Thank you very much. Thank you again, Madam Chair and members. And as you know, data breaches are becoming increasingly sophisticated. Hackers are constantly looking for new and innovative ways to penetrate networks, such as gaining access to encryption keys or security credentials in order to access encrypted information. For example, in February 2015, criminals accessed personal information, including names, addresses, birth dates, and social security numbers of more than 80 million patients covered by one of the country's largest health insurance and health plan providers. The incident was the biggest theft of healthcare data in our history. The data was not encrypted, which is what triggered a data breach notice to the 80 million victims under current state and federal laws. However, even if encryption had been used, the data could still have been compromised because the hackers also gained access to at least 5 sets of employee credentials, which could have been used to unlock any encryption. Security experts contend that encryption by itself cannot thwart criminals if the hack involves gaining access to security credentials. AB 2828 simply expands the data breach notification law, which currently requires notice to consumers of compromised unencrypted personal information to also include encrypted information if the encryption keys have also been compromised. The bill is supported by the ACLU, California District Attorneys Association, Consumer Federation of California, Electronic Frontier Foundation, and also the Privacy Right Clearinghouse. With that, I respectfully ask your aye vote.
Move the bill.
Thank you.
Good idea.
Thank you. This bill sounds familiar to an analysis that was done by my staff here last year, so he's very pleased that someone was reading his work. And, thank you. Any witnesses in support? Any witnesses in opposition? All right, please step forward. You take a seat. You don't have to stand up if you would like to. You get 2 minutes to state your opposition.
I'm simply stating a me too, Danielle Kando-Kaiser, on behalf of Electronic Frontier Foundation and Privacy Rights Clearinghouse in support.
Thank you. Very good. Any witnesses in opposition? We'll bring it back to the dais. Senator Hertzberg? Senator Hertzberg moves the bill. All right. There doesn't seem to be a desire for much further debate or discussion. I won't say anything negative if I want to keep my good staff on board. Another fine job by...
Offer an amendment to call this Toby's Law?
Toby would appreciate that. But, and I appreciate the work you've done to move this forward, and we do have a motion, so I assume you're asking for an aye vote.
Absolutely.
Very good. Please call the roll. And the motion is do pass to Senate Appropriations.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno, Monning, Guykowski.
Aye.
Guykowski, aye.
That bill has 4 votes. We'll leave the roll open for absent members. Thank you so much, Assembly
Thank you,
Member.
Mitch. Let's vote on the other ones. You got a bunch of them to vote on. Where's? Hey, come on, we'll amend this, I'll offer an amendment. Look at Morlock, looks so serious. He's a Viking, that guy.
No, he's from the Low Countries.
I know he's from the Low Countries, but he looks like a Viking.
You have two bills up. We'll start with file item 16, AB 2349, and then we will go on to file item 23. So we'll start with file item 16, the gestation, no, wait a minute, file item. Yes, gestational carriers. Good afternoon, Assembly Member.
Thank you for having us, Madam Chair and Senators. This bill, AB 2349, would protect parents of children conceived through surrogacy in our state, including straight and LGBT couples, from having their rights violated outside of California. Our state has been a leader in surrogacy law, and because it's known as a surrogacy-friendly state, many couples from other states seek Californian surrogates to carry their children, which has led to a shortage of California surrogates, ironically pricing many of our parents out of the market, forcing them to look to other states for their own surrogates. Our state has had a clear interest in stating when a court has jurisdiction to protect the rights of these parents, their children, and California surrogates. When dealing with litigation in other states that have been less friendly, in particular to LGBT individuals, our California same-sex parents have needed the protection of California court orders. This bill clarifies when our superior courts can take jurisdiction in parentage cases resulting from gestational surrogacy arrangements. Without clear statements in the law, questions can arise when courts of other states consider our orders. This bill also clarifies that when intended parents are using donated eggs or sperm, the names of donors need not be named in surrogacy contracts to protect a donor's privacy. This bill was unanimous and bipartisan in the Assembly, and I respectfully ask for your aye vote and turn it over to one of our sponsors.
Thank you very much. Good afternoon.
Good afternoon. Shannon Smith-Crowley, representing the Academy of California Adoption Lawyers. The analysis lays out the arguments beautifully. I think that'll be my statement, and we ask for your support.
That was short and brief. Thank you very much. Any witnesses, other witnesses in support? Any witnesses in opposition to the measure? Any witnesses in opposition? Seeing none, any questions from the dais?
I think any analysis that quotes International Shoe versus Washington is exemplary, and I will move the bill.
No, exactly the opposite.
Oh.
Not move it.
International shoe. Ooh, that does raise some
Oh, my God.
vivid and not very great old memories.
I'm not going to comment on International Shoe.
Certainly the fundamental.
What's the holding in International Shoe, Mr.?
Oh, my goodness. What number is this? Which bill number is this? What number? Right. Are there any other questions? Senator Morlock, would you like to know a little more about International Shoe? No. All right. As a non-lawyer, as the only non-lawyer up here, and I think our colleague here understands that we're going deep into the bowels of fundamental civil procedure, and certainly its relationship to this bill is of great interest. But with that, we have no other comments or opposition, so we do have a motion by Senator Wojtkowski. The motion is due pass to the Senate floor. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Monning? Wojtkowski?
Aye.
Wojtkowski, aye.
That bill has 4 votes, and we will hold the roll open for the absent members. And now we have file item 23, AB 2819, file item 23.